Okay, well, it's not even Halloween anymore.
Yeah.
So we'll get through it. Okay, so it is November 3rd, 2022, just after 1:15 p.m. This is the continuation of the 6th day of the hearing by the Administrative Hearings Office in the court's referral to the State Water Resources Control Board in City of Marina versus RMC Lonestar. And it looks like appearances are all the same as they have been. So before the lunch break, we had an offer of exhibits from the City of Marina, and I will just repeat. It was an offer of exhibit Marina 1, 8 through 11, 19, 24 through 27, and 32 and 33. Are there any objections to any of these exhibits being received into evidence?
Yes.
All right, go ahead, Mr. Betts.
And Mr. Osias and I, and perhaps others, will be addressing these, not to tag team everyone, but each of us handled different witnesses. And Mr. Moore may address it as well. So if that's okay with you, Mr. Lilly.
Yeah, that I understand under these circumstances. That's fine. Just whatever you do, talk slowly so we can write down the numbers, but go ahead.
Will do, with the general caveat that admissions to exhibits here are not meant to be admissions to exhibits in the state court action. I'll start with Marina number 11.
And just so we're clear on that, Mr. Betts, that was something that Marina Coast and City of Marina's attorneys asked us to note as well. So it's noted now for Cal-Am as well.
Thank you.
That certainly is my understanding, that judge can do whatever he deems appropriate with these exhibits.
So I start with Marina exhibit 11.
Okay, let me just get it here so I can see what it is. Okay, go ahead.
Sure. Our amongst our objections, it being hearsay, no foundation. I'm not sure if it was referenced by Mr. Long, but if so, it predates his involvement. It's irrelevant, and critically, it's just a self-serving document that had no foundation on many accusations about Cal-Am and the project.
Okay, so on that, I'm going to rule one at a time. I think it'll make it a lot easier for us to keep track of them. Is that the extent of your objections to exhibit Marina 11?
That is.
Okay, so I'm going to overrule those objections. As far as the hearsay objection, I'm pretty sure this is under the exception as an official act by a government agency, which is one of the exceptions to the hearsay rule. I don't think there's any question about the authenticity about this. I'm not sure if Mr. Long specifically referred to this, but unless somebody offers any evidence to the contrary, I'm pretty confident that the City of Marina actually did in fact adopt this resolution on the date indicated here. It is signed by the chair and attested to by a senior planner. And as far as relevance, this is all background. I tend to agree with you, Mr. Betts. It's certainly, I'll just say, the City of Marina's position on these issues as stated by the Planning Commission. And of course, there's a Coastal Commission appeal to the Coastal Commission pending. So I don't think it has huge relevance to the issues that the court has referred to the State Water Board, but I'm going to admit it into evidence for the limited purpose of potentially providing some background information. So please go ahead.
Thank you. It's for Marina 37 and 38. Just a quick question. Is
Wait just a minute. Oops, those I don't have paper copies of. So go ahead and tell me your objection. I may have to pull them up. Go ahead.
Right now, it's a question that may morph into an objection, but these are deposition excerpts from Tim Durbin and Peter Leffler. Are they the excerpts that were read into the record? Or we discussed those, I think, last week. Are those the same exhibits?
Okay, so Ms. Meisenheimer, please state if you can answer Mr. Betts' question.
Those are the same exhibits. They are the portions that were read into the record. Cal-Am had requested that a few additional pages go with, I believe it was Mr. Leffler. We added those, and so this exhibit has those pages as well.
Thank you for the clarification, counsel. And with that, no further objections to the Marina exhibits.
Okay. And does anyone else have any objections? Okay, hearing none. And I wasn't sure, did you check, Ms. Meisenheimer, whether we previously admitted 34 through 38?
You know, my understanding is that they were previously admitted, but it's been done somewhat piecemeal, so it might be cleaner if we just admit them all at this point.
Okay, so and that's fine. So I will admit into evidence exhibit Marina 1, Marinas 8 through 11, 19, 24 through 27, and 32 through 38. And I've sort of said this earlier, but I'll say it now. I request that one attorney for each party check the Excel file that we have posted with that party's exhibits and make sure it's up to date. And if it's not, there's no way you can take an exhibit down after we post it, but you should have, you can download the Excel file. So I would request that each of you update the Excel file listing your party's exhibits as necessary. And if you can do that by the end of the day tomorrow, I would appreciate it. I don't think it's super long. You have already done about 95% of the work. And then what we will do is my staff then will go through the hearing recording and list the dates on which exhibits were offered and either admitted or not admitted into evidence. And we will post that back to the exhibit file, the folder of each party's exhibit. So then we should have a clear record of what's been admitted and what's not. I mean, obviously there's some that we haven't covered yet. And we will let you know when we have done that. So is that clear for each party to do that? Oh, okay, thank you. So that takes care of Marina's exhibits for today. We did have Mr. Newdecker offered exhibit SEMEX 1. And was there any objection to that?
So, Mr. Lilly, as I noted, we have some concern that it is an unsigned document, so it's not final. I think given the way we're handling exhibits here, that's likely to go more to the weight than the admissibility, but we would defer to how the AHO wants to handle that exhibit.
Well, this one, I have to say, there is no foundation whatsoever for this exhibit. Mr. Newdecker has represented, he obtained it from some City of Marina file, and I'm sure that's correct, but we don't have any authentication of it from any witness, and we don't know what happened to it. It's unsigned. We don't know whether it was really submitted to the City Council or whether it was just a staff draft. So I have to say, Mr. Newdecker, I am not going to admit exhibit SEMEX 1. Now, if you want to follow up on that and can provide some authentication, even if it's just having some witness testify, I went to City of Marina's files and I found this exhibit, that could be sufficient, but we don't have even that right now. All we have is Mr. Long saying, I've never seen this before. I don't know what it is. So at this stage, exhibit SEMEX 1 is not admitted into evidence. And but I will leave it open for Mr. Newdecker to follow up if he wants to provide some authentication. And if you want to do that, Mr. Newdecker, our hearing starts again in December. I think it's December 7th, if I'm not mistaken. So if you can, by December 2nd, if you want to offer some very short proposed written testimony from some witness who can authenticate exhibit SEMEX 1, or in an ideal world, a signed version of that, then I will reconsider admitting it. But at this point, I'm not going to accept that into evidence.
Thank you.
Okay, so that takes care. Were there any other? I don't think there were any other cross-examination exhibits that have not already been admitted into evidence. Does anybody think that there were?
Mr. Lilly, I'm not sure how you're characterizing. I know CalAm does have some exhibits they've introduced in just the last few days that haven't been addressed yet.
We'll get to those. I meant ones that were covered during this morning's cross-examination of Mr. Long. Okay. I didn't think there was anything else, but I just want to make sure. So we will now turn to Marina Coast exhibits, which we were not able to address on Tuesday. Mr. Brochard has submitted an email to the AHO with CCs to the parties and a list of Marina Coast exhibits. And I'll just read Mr. Brochard's email is offering for admission into evidence exhibits MCWD 1, 4 through 8, 27 through 40, 58 and 59, 70 through 72, 74, 76 to 89, 91, 100, and 106 through 109. Is that in fact correct, Mr. Brochard, that those are the exhibits that MCWD is offering into evidence at this time?
In this phase, yes.
Yeah, and I understand there will be more exhibits offered later after the MCWD's two technical experts testify.
And Mr.
So-
Lilly, just to clarify, I believe 106 and 107 were the excerpts of Dr. Ye's deposition that were previously offered and accepted into evidence, along with MCWD, I believe 103, 104, and 105 last week.
Okay, so 106 and 107 were previously accepted into evidence?
Yeah,
believe
those are
that's
the
correct.
actual physical excerpts from the deposition that were read into the record.
Okay, thank you.
And to
That's
be
why it's-
clear, on 106 and 107, you've only attached a front page and those pages that were referenced. And I think that was the homework you guys were going to do.
Yes,
Is that correct, Mr. Brochard or Ms. Musin?
yes, that's what I attached, and I blocked out the portions that were read into the record.
You mean so
There's
we
like
just
a line
read those.
just to like identify what was read into the record.
Okay, that should be pretty clear. And that's the protocol we followed for deposition transcripts, because we definitely don't want the entire deposition transcripts coming into evidence when most of it has not been covered. Okay, so with that, are there any objections to those MCWD exhibits being admitted into evidence?
Yes.
Okay, go ahead, Mr. Betts.
I will address
Excuse me, before Mr. Betts gets started, to the
Okay,
extent.
go ahead, Ms. Musin, go ahead.
To the extent any objections go to exhibits regarding Mr. Schertzinger's testimony, I'll address those. To the extent any objections go to exhibits related to Dr. Ash's testimony, I believe Mr. Wilkins will be prepared to address those.
Yeah, that's fine. You're all doing pretty well, not speaking over one another, and I'll try to do as well. So just with whoever needs to speak up for any particular objection, that's fine. All right, with that, Mr. Betts, please go ahead.
So for exhibit 6, we just respectfully requested confirmation that these have not been altered and they're complete records.
Okay, you know what I'm going to do? I've got a binder of those exhibits, which will be a lot quicker if I just get it. So let me just be right back. This is the perils of paper exhibits. They take up a lot of volume. Okay. Exhibit MCWD 6 is several pages of well logs. And Mr. Betts is just asking somebody from Marina Coast Water District to confirm that there have not been any alterations of these well logs. Is that your request, Mr. Betts?
And that they are complete.
And that they are complete. Can somebody from Marina Coast answer that question?
Of course, Mr. Lilly. And as mentioned in Mr. Schertzinger's direct testimony, I believe it is stated that those are true and correct copies of DWR's records, but to the extent that that was unclear or Mr. Betts missed it, they are indeed true and correct copies of the well logs available from DWR as downloaded from their website.
Okay, I detected a little bit of criticism of Mr. Betts there, and I don't know whether that was intended or not, but that's
I apologize. It's simply that we've got a lot to contend with here, and maybe our memories of our own exhibits are very clear and of others perhaps not so much.
okay. Well, anyway, it's a fair question by Mr. Betts. With that representation that these are complete and unaltered, is there any objection to MCWD 6?
No.
Okay, so let's go ahead. Keep going, Mr. Betts.
Number 8, for Exhibit 8, the gist of the objection is no foundation in relevance. And to be specific, it seems just like printed out pages of data, and then if you flip through it, some pages are even blank. So I'm not sure what it is, who created it, what it's.
Okay, and I haven't gone back to check if this is referenced in Mr. Schertzinger's testimony anywhere. Does somebody from MCWD have a response?
Yes, Mr. Lilly. As shown on page 7, lines 19 through 21 of Mr. Schertzinger's testimony, these
Okay,
are
hang
true
on,
and
hang
correct
on.
copies.
Let me get, what exhibit is that?
That would be MCWD 1.
Shoot. Not doing as well as I thought here. I'll have to go electronic on that. So let me get exhibit MCWD 1. All right, which page, Ms. Mazine?
Page 7, line 19, toward the end of the line. True and correct copies of MCWD's well production summaries for 2006 through 2020 are attached hereto as Exhibit 8, and the Bates numbers are stated.
Okay, so Mr. Betts, that does seem to authenticate exhibit MCWD 8. Do you still have an objection to that?
I do, just there, I don't see the foundation for it. And again, if you flip through it, certain pages are blank. So it just doesn't seem to match up to what's being represented. There's no line numbers, there's no basis for it. It's just a page of, it looks like something may have been cut and paste with blank pages. I mean, I don't say this for a lot of these. I've got issues with a lot of these, but for this one, it's just anybody could have printed this. I don't see where it's coming from, where it's not tethered to anything.
Well, it's okay. I don't see any blanks in it. It seems to have every month of the years covered.
My binder's in a different room, but I know when we were just flipping through it, certain pages are blank.
Okay,
Mr. Lilly, I'm sorry, I didn't mean
go
to.
ahead. Go ahead.
If I may, I don't think that in any way diminishes Mr. Schertzinger's testimony that these are true and correct copies of records of the district for which he's general manager. And to the extent that formatting of an Excel sheet as it was converted to a PDF may have resulted in something aesthetically less pleasing than some might like to see, I'm sure Mr. Schertzinger would be happy to answer any further questions you might have.
Okay, I'm going to overrule the objection. I do think Mr. Schertzinger's written testimony is adequate to authenticate that exhibit MCWD 8. So I will admit it into evidence. Any further objections to MCWD exhibits?
Yes.
There are, and I'm turning that over to Mr. Osais.
Good afternoon, Mr. Lilly. I'd like to start with MCWD Exhibit 28. It has a very long title, but Dr. Ash repeatedly referred to it as the Stanford 2017 study, to refresh your recollection.
Okay, I do see that here.
And
what's your objection?
My objection includes a variety of items, so let me go through it. First, this is not a study that informed his direct testimony. It was a study in which someone cut and pasted some of it into his testimony. Second, he acknowledged he had not written it. Third, he acknowledged that his participation in that study was 2% or less. Next, he admitted that this study included application of AEM data by a hydrogeologist, but none of that application work was provided. Next, he admitted, and some of this was even to your questions, that there was modeling work that went on by a Mr. Gottschalk, a graduate student. And unlike every other witness for which modeling occurred, nothing was provided about that modeling work, not the model, not the input files, not the assumptions. Fourth, the authors were not made available the authors were not put under oath. And next, the authors were not available for cross-examination. And so for all of those reasons, it's objectionable and should not be admitted.
Okay. So those objections are overruled. Dr. Ash did testify enough to authenticate this, so I don't think there's any question about the authenticity. I also think it has relevance to the issues in this proceeding. I think, Mr. Osias, your objection that these witnesses are not available really is an objection that it's hearsay. And I think that objection is valid. So I'm going to admit this under the rules in Government Code 11513, but subject to the limitations in subdivision D of that statute on the use of hearsay evidence, which is basically that it may be used to supplement and explain other testimony, but I'm paraphrasing, but it basically may not be used on it, by itself. So the objection is overruled. Exhibit MCWD 28 is admitted, but subject to the limitations on use of hearsay evidence stated in Government Code 11513 subdivision D. Okay, you may proceed, Mr. Osias.
And so I have similar objections to some other Dr. Ash documents. So if I say the same objections as number 28, I hope that'll be sufficient unless
that will be fine. Thank you.
Okay. But that's not regarding my next objection. My next objection is to MCWD 31. And I have the same objections for 32, 33, and 34. But if you start with 31, my objection is lack of foundation. Dr. Ash didn't testify to Exhibit 31. It is undated, it is unsigned, it is unidentified. There's no legend for what it, either the columns or the numbers mean, and nor is there any explanation. And so all of that makes the lack of foundation relatively important.
All right, Ms. Muzine or whoever else who wants to respond for MCWD.
I can respond, Mr.
Go ahead, Mr. Brochard.
Mr. Ash addressed this exhibit on page 15 of his testimony. It's MCWD Exhibit 4.
Okay, I do see here, it says the database and location files are included in exhibits MCWD 31 through 34. So is there anything further you want to say in response to Mr. Osias?
Yes, thank you. I think Dr. Ash admitted he didn't.
Wait. I'm sorry. Mr. Brochard, is there anything else you want to say in response to Mr. Osias, is what I was trying to say.
It's in the middle of the page. He identified what these are. There's also a footnote which states that exhibits 31 and 33 are the well locations that were used in both the 2017 and the 2019 AEM studies, respectively. And then he also identifies in footnote 2, MCWD exhibits 32 and 34, which I'm sure we'll address in a minute, as being the lithology data used in the 2017 and 2019 AEM studies, respectively.
Okay, so Mr. Osias, now you may respond. Go ahead.
Thank you. I did not mean to speak out of school.
Oh,
My
sorry.
response would be that Dr. Ash admitted under oath that up through page 50 was not written by him. And so we don't have a foundation because we don't have a witness who wrote it.
Okay, so the objection is overruled. I mean, he did affirm that this was his testimony. I think that is sufficient to authenticate exhibit MCWD 31, and I'm not hearing any other objection to that. So exhibit MCWD 31 will be admitted into evidence. So go ahead, Mr.
So
Osai.
I had the same objection, and not to repeat it, and with the same lack of foundation, and it wasn't his testimony to 32, 33, and 34.
Okay, and I will make the same ruling. Those exhibits are admitted into evidence.
And
Okay,
then, yes.
continue, please.
Yep. MCWD 35 is the published article based on the 2017 study that Dr. Ash again testified he didn't write and had very little involvement in, and all the other reasons I mentioned for exhibit 28. A lack of foundation, hearsay, authors not available, data not provided, modeling not provided, lack of opportunity to cross. And he testified expressly that the only thing he knew about the article is what he was reading.
I don't remember it that way. I thought he testified he was much more involved in preparing the 2019 article, but I'm going to ask MCWD if some attorney wants to respond to that objection.
I'm wondering, this is Mr. Wilkins, that if 20, when I'm looking at it, unfortunately, I'm looking at, I think we had a corrected version of one of them, and I want to make sure that we have the correct, because when I look at these two, they're the same exhibit in one of my folders, and I have to go to another folder to find it. So
I can explain if I might.
Well, I don't know, Mr. Wilkins, is there anything else you would like to say before Mr.
Well, I guess
Osias?
most importantly, I think that some of what's being said that Dr. Ash didn't write his testimony is an overstatement. And I think you recognized, Mr. Lilly, that he did testify it was his testimony. And as I think anyone who looks at it will notice that it came out of the studies. It wasn't written by attorneys. At the same time, I do recognize that that there were others involved that he relied on for his work at Stanford, and he has testified that he believes that their work was true, and that he confirmed that with his 2019 study. So the idea that he doesn't know what happened, he doesn't know some things that Stanford did, but I don't think he's testified that he doesn't understand the 2017 study. He specifically said he agreed with the opinions and conclusions, and that his 2019 study confirmed and was consistent with what Stanford had determined in their interpretations. So I guess, I recognize that he had some uncertainty, but I don't want to suggest that he said that he had nothing to do with the first 50 pages. It was from a report that he was involved with, and he confirmed he was able to confirm those conclusions, even though he didn't write the original report.
I think just more specifically to this, because I think this objection is about Exhibit 35. Exhibit 35 is
Yeah.
It's a journal article.
Right.
My understanding is the 2017 report was turned into a journal article and peer reviewed and published in the Geophysics Volume 85, issue number 4. And that's what this is.
Correct.
There's any doubt to that.
And Mr. Wilkins is right that originally the 2017 study, which is Exhibit 28, somehow also got labeled, the article got labeled with the same number. So
Right,
he
and
clear-
that was a clerical error that we corrected though.
Right, and that's why it's 35. And just to make sure there's no confusion, Mr. Lilly, the 2019 study, which had two versions, are exhibits 29 and 30. I did not object to those. So this is, as Mr. Brochard said, an objection to a publication, to an article published, to which he testified he had little to no involvement other than proofreading.
Okay, so this is not the 2019 article that he testified he'd spent more time writing than.
Right. This is not the 2019 report, the technical reports that he wrote, either the draft or the final. I don't know
Okay,
what you mean
okay.
by article.
But he did reference this in his testimony. It is a published peer-reviewed article and something that experts are allowed to rely on.
Yeah, there's no doubt about that. The question is what it should be admissible. So unless I'm hearing anything more, I think my prior ruling on Exhibit MCWD 28 applies here as well. This is an article that he may have had some involvement in, but fairly limited. But it is certainly, it's been authenticated and it appears to be a valid technical article. So I think the way the Water Board normally handles this is appropriate here, and that is, I will admit Exhibit MCWD 35, but subject to the limitations on use of hearsay evidence that are specified in Government Code 11513 subdivision D. So let's move on.
And
What else do we want to cover?
so, Mr. Lilly, just so our record is complete, exhibits 38 and 40 are presentations dependent on the 2017 study. They predate the 2019 work. And so I'd have the same objections I had to MCWD 28, and I presume you have the same response.
Well, no, don't jump to conclusions about that. 38 is a technical memorandum prepared by Dr. Ash. Am I looking at the right exhibit here?
You are, but it's totally dependent on the 2017 study.
Okay, well, but it's not hearsay if he prepared it and was available to testify. So I don't think it's going to be subject to the same treatment. I mean, this is a document, I mean, as far as we can tell, he prepared it. Now, he may have relied on other things, but as a technical expert, he's allowed to rely on other technical information. So unless you have some other objection, I believe 38 is admissible. Okay, so hearing none, I accept Exhibit MCWD 38 into evidence. Now, I think, Mr. Osias, Exhibit MCWD 39 may be a different story because that is something, it's on the Stanford University letterhead. And it was signed by Professor Rosemary Knight. So do you want to state an objection to that? Because I think that's in a different evidentiary posture than Exhibit MCWD 38.
No, we'll let that in.
Okay, Exhibit MCWD 39 is admitted into evidence. Keep going. Any other objections to MCWD exhibits?
Yes, exhibit 58.
Okay,
The objection is lack of foundation. You'll recall that Dr. Ash testified he was not asked to investigate anything offshore. They did no flights offshore. He made no reference to submarine groundwater. He didn't testify that he relied on this. So objection based on foundation.
on MCWD, any response?
My recollection, assuming this is correct, and I have to go back and backtrack quickly because I didn't know there was an objection here, is that this was a reference in his reports to this article, and that's where it comes from. Unless I'm wrong about that, what we did is we provided all the reference materials that were included in our experts' reports. It's possible we made a mistake, but assuming that this was a reference in his report, we were just trying to be forthright and give everything to the HO that we referenced. So there's, I think CalAm did the same thing with some of their exhibits. You know, that is my recollection, is that this is a reference material, and I would have to go back and look at his testimony to confirm that.
Okay, can anybody for MCWD tell me if this is cited anywhere in his testimony?
I don't think it would be in the testimony. I think it would be cited in one of the reports, and I am not positive which one.
Okay. I mean, cited in another report, basically?
He attached his reports, and what we had done, and I think he testified, is that in the belief that we wanted direct testimony, we had converted the reports to direct testimony, and then he edited them. But there was nothing. Basically, what we tried to do is get all the reports that he had worked on into testimony. So, and he references the reports in his testimony. So what we asked him to do was provide all your reference materials to us so that we can provide them as exhibits. And this was one, I believe, unless I'm wrong, that he provided to us. So it was one of his reference materials.
Okay, well, you know, I'll just say I don't know how relevant it is to what I'm going to do, the issues I have to address, but I'm going to admit it into evidence subject to the limitation on use of hearsay. I mean, again, I don't think there's any question about authenticity. There is some question in my mind about relevance, but certainly it's hearsay. But I'm going to admit.
I'm sorry, but I do
Go
want to
ahead,
remind
Mr.
you.
Osias.
I just want to remind you, I don't have a transcript, but when I asked him questions about studying water offshore, he said it was not within the scope of what he had been requested to do, and he didn't do any.
For this particular project, he said, he didn't say he'd never done any. He said, did you study offshore here? And he said, no.
Correct. I agree with
Okay,
that.
I'm going to let it in. I'm going to accept it into evidence subject to the hearsay provisions of Government Code 11513 subdivision D. I mean, I'm really on the fence on this one, but it's possible that, very unlikely, but possible it may have some relevance to explaining his testimony. So I'm going to admit it for that purpose, but I will certainly note that CalAm can raise the issues regarding what weight, you know, if MCWD cites this, and I don't even know if they will, but if they do, CalAm certainly can raise the issue as to what weight we should give to this exhibit, because it certainly doesn't look like it deserves a lot of weight in this proceeding. So that's my ruling on MCWD 58. So go ahead, Mr. Osias.
Thank you. In the interest of time.
Mr. Lilly, if I may, I'm not sure if we resolved 59, which Mr. Osias also mentioned. And I just wanted to point out that 59, the MacTech article.
I didn't mention 59. I'm sorry.
Oh,
Yeah,
I
I don't have any objection to 59 in front of me yet.
Thank you.
If I do, I'll call on you. Go ahead, Mr. Osias. I may not. I may not have an objection, so go ahead.
Yes, I was going to ask if I might address, since I've taking into account your prior comments, exhibits 71, 72, 76, 77, 78, 79. We'll start with those. Those
Okay,
are,
well, I can only go one at a time, so go ahead, 71.
I believe, I will take Mr. Wilkins' word for it that this was listed as a reference. And that's in the interest of inclusion, they posted it. But my objection to all of these is he did not testify that he relied on any of these. So lack of foundation. They're not reports for this work. So there's no reliance on them in his testimony. They're all the third parties.
And Mr. Lilly, these are all, some of them I think were actually authored by Dr. Ash, but all the exhibits that Mr. Osias just listed are references in either the 2017 or the 2019 report.
Okay, so let me get the numbers here. It's MCWD 71, and what else, Mr. Rosales?
72,
Okay,
76,
okay,
77,
all right,
78,
all right,
79,
okay. Is that it?
and yes, and 79. Thank you.
Okay,
And in the entrance of completion, 76 has his name on it. The rest are authored by other people.
all right. I appreciate that clarification. So, okay, well, 77 also, he's listed as the first author of 77, right?
Oh, I apologize. Yes, that's correct.
Okay, so I think I'm going to, I think these basically are all going to fall into the same category. That there may be some limited discussions of these. I mean, frankly, I don't know how much time I and my staff are going to spend going through these. So we're only likely to get involved with them if somebody cites them in either their proposed reports, which I discussed this morning, or their closing briefs. So I'm going to admit them into evidence, but subject to, for 70 exhibits, MCWD 71, 72, 78, and 79. I'm going to admit them subject to the rules on hearsay and Government Code 11513, subdivision D, and with the understanding that if MCWD relies on these, CalAm certainly has a right to discuss what weight I should give them. 76 and 77, since each of those, Mr. Ash was listed as the first author, which I think means something. So I don't think those are hearsay. I think those are within the scope of his testimony. So those I'm going to admit without any limitation. So, okay, let's keep going.
And we object to MCWD 80. Now, this was the Florida study of AEM and chloride. And so I acknowledge that he laid a foundation of authenticity. And he relied on this study, but I'd object for foundational reasons that he provided no information allowing comprehension of how a chloride study is converted to a TDS knowledge. So I would object on the grounds of relevance.
Okay, this one, I don't know if I can get it. It's so big. I don't have a paper copy. It was more than 100 pages. Here we go. So let me get it here. Okay, so the relevance objection is overruled. I mean, certainly there's been discussion about equivalence between TDS and, or not equivalence, but how TDS numbers and chloride numbers correspond. So I don't think that objection is appropriate. Again, this is really in the same category as a lot of these technical reports. This one he was not listed as an author of. So I'm going to admit Exhibit MCW 80, but subject to the limitations on use of hearsay in Government Code 11513, subdivision D. So, and again, with understanding CalAm's right to discuss what weight should be given to this exhibit. So, Mr. Osias, please proceed.
Thank you. The objection to 81, 82, 83, 84, 85, 87, and 88 are all lack of foundation. He's not an author, to inform you at least. third-party documents, no testimony that he relied on them. They're merely cited. And so it's a similar objection that to others you've ruled on.
Okay, and they are apparently listed in his references, so I will make the same ruling on those. They're admitted, subject to the limitations on use of, this is exhibits MCWD 81 through 84 and 87 through 88, are admitted into evidence, subject to the limitations on use of hearsay evidence in Government Code 11513 subdivision D, and subject to Cal-Am's right to raise the issue as to what weight the AHO should give these exhibits if MCWD in fact cites them in any of its subsequent arguments or briefs. Okay.
Thank you, Mr. Lilly. And I think you omitted 85, but it would be the same.
Oh, I did not write down 85 before. Maybe I did miss that.
That's
So, okay, so exhibit MCWD 85 is admitted into evidence subject to the limitations on use of hearsay evidence in Government Code 11513 subdivision D, and subject to Cal-Am's right to raise an argument as to what weight should be given to this exhibit if MCWD cites it in its subsequent arguments. Okay.
Thank you. And the next exhibit would be MCWD 108. I know Mr. Betts made an objection after Dr. Ash's testimony that you addressed. So I don't expect you to change your ruling, but I didn't want to have anyone think our not raising an objection to the written form of his testimony somehow it changed our position. So our objection to 108, which is his slides, is the same as the objection we had made at the end of his testimony. And we understood your ruling from that day. If you want to just say it's the same ruling.
Okay, well, let me just, so this is his revised summary slides. First of all, so what is the specific objection to exhibit MCWD 108?
It's not his testimony, a lot of it. It's merely cutting and pasting of other people's words. A lot, you can see pronouns of we, his direct testimony using these slides. He used the pronoun he, referring to Mr. Gottschalk. He said he didn't know when asked questions behind these slides, as he did with respect to the written direct testimony. His answers were similar. So we have the same concerns.
Okay, so I'm going to make the same ruling. I stated my concerns before about Dr. Ash's written testimony. I think he may have shown a little more personal knowledge about these slides than he did about some parts of his written testimony, but the same general comment applies. I think the objection goes to the weight, not the admissibility. I mean, he did testify these were his slides, but as I said before, I was troubled that some of it seemed to have been materials that were prepared by the attorneys without a lot of thorough review by Dr. Ash. So I certainly am admitting them, but subject to Cal-Am's right to raise issues regarding what weight should be given to these exhibits.
Thank you. Again, we just didn't want our silence to think we had a different view of his slides than his testimony. Lastly,
Okay. Well, that's my ruling on that, on exhibit MCWD 108. So,
and then MCWD 109, it is a report by somebody from 2008. So the objection is lack of foundation, not his testimony, not even his reliance on it, other than to, I think, admit that someone else created 3D models.
I think this may be the article that I asked Dr. Ash to submit. Is that correct, Mr. Wilkins?
That's correct. And I just assume generally that these hearsay exceptions apply to all of the hearsay documents that everyone has submitted in this case. So we have not objected on the grounds of hearsay for documents knowing what the government code says. And you asked a number of people to provide you with references or homework. And I assume we don't need to object to that on hearsay grounds. That it wasn't part of their testimony. But if you want to clarify, that'd be helpful to us to know.
Well, first of all, it's admitted subject to the same ruling regarding hearsay. Since an objection was made, I do have to rule on an admission, but let me just check here. So I think we may be able to. Okay, and again, maybe I'm getting bogged down applying technical rules of evidence to what should be an informal proceeding on a court reference where we're not necessarily subject to all of the rules of evidence, but so far I have been applying them. In Government Code 11513, subdivision D states, hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but over timely objection shall not be sufficient in itself to support a finding unless it would be admissible over objection in civil actions. And that's the basis of my rulings on that. But the next sentence is important here for what Mr. Wilkins just said. An objection is timely if made before submission of the case or on reconsideration. So, and this may save all of you a lot of work. I don't think I mean, it's okay that Cal-Am objected to these exhibits. That's certainly their right, but I don't know that you need to. If I end up citing any of these exhibits in our draft report of referee, and somebody wants to object to my use or citation to such an exhibit on the grounds that it's hearsay and therefore it's subject to this limitation, they can make that objection, and that would be before submission of the case, because submission of the case we will take to be after the publication of draft, but before the final report goes to the State Water Board. So I think, I mean, I don't know that this is going to be a big issue, but if somebody thinks that our draft report cites something and uses it, it's a hearsay document, and we use it in a way that's inconsistent with the statute, the party may make the objection at that time. As I say, I don't think that's going to be a lot of documents, but if it is, that may be done that way. So, Mr. Wilkins, does that clarify that point for you?
Yeah, I just wanted confirmation. Thank you, Mr. Lilly.
Okay, whoops. Just drop the government code. Go ahead.
Mr. Lilly, specifically as to 109, I believe it is substantially the same document as what you already have as Exhibit 88, though there may be some download dates reflected on one that are not reflected on the other. I don't know that Mr. Osias raised the same objections to 88, but in either case, we don't mind having the document in twice, but for clarity, perhaps we should just stick with 88.
Okay, well, I've admitted 109 subject to those limitations, so let's just leave it the way it is.
That's fine then.
Yeah, I'm certainly hesitant to not allow admission of a document to evidence when I ask the witness to submit it. That would be inconsistent, I think. But I think subject to that limitation should take care of that.
That's that's fine. I just wanted to make sure we're all aware that we're dealing with basically the same document.
That's fine. Thank you. Okay.
I did not realize that because the authors were not repeated. Sorry.
Well, and if they are, then they are, and if they're not, they're not. And I don't think we've ruled on them as we've ruled on them. So we'll proceed. I will, I'm going to state the obvious. I mean, there are thousands and thousands of pages of exhibits here, literally thousands and thousands of pages. And I don't think you should assume or expect that I and my staff is going to read every page. We're not. Just tell you that. So if you think there's something buried in one of these exhibits that's relevant to the issues the court has referred to the State Water Board that you want us to consider, it's up to you to make sure to point that out to us in your proposed or draft proposed report of referee that I told you I'm going to ask you to submit, or in your closing briefs. So anyway, that should be obvious, but I want to make sure it is clear. Okay, so with that, have we now covered all of MCWD's exhibits being offered into evidence and my rulings on those?
I believe so.
Okay, good. Thank you. I think we have too. and we've covered Marina's exhibits, and we've covered RMC Pacific Cemex's exhibits. So we are left with Cal-Am exhibits, and there were some that last time, I'm sorry, I've lost track of dates. It may have been Tuesday, but I'm not sure, that were offered. And I said, well, we'll wait and rule on those after we've had the cross-examination, and also to give a chance for Cal-Am to basically represent to MCWD that some of these MCWD documents were in fact downloaded from the MCWD website without alteration. So my notes had that I had not ruled on exhibits Cal-Am 90 through 102. First of all, is that correct? Are those the ones that we're waiting for rulings on?
My understanding was that Cal-Am had narrowed the scope of that in what they emailed in yesterday. And so there's a subset of that, 94 to 96 and 99 to 102, that they actually offered.
Okay, so I'll start with whichever Cal-Am attorney wants to respond. Mr. Osias, you're going to respond. Of Cal-Am 90 through 102, which ones, I don't think any of them have been admitted into evidence. And if that is in fact the case, which ones of those do you want to offer into evidence?
All of them.
Okay. And that's fine. And if the email said something different, I'm going to go with what Mr. Osias just said. I mean, you may have noticed I tend to err on the side of letting documents in, but subject to limitations where appropriate. So with that, Cal-Am's 90 through 102, are there any objections to any of those exhibits?
Just
Mr. Lowe, apologies. With Cal-Am having narrowed the scope of what they said they were trying to admit, there are some of those that we did not look at in this discussion. And so we might need to reserve our rights to revisit a few of these.
Okay, most of these I think are government, the others are government documents. So I don't really think there's going to, 90 through 93 are all government documents that I'm pretty sure we can take official notice of as under the official records exception. But if you want to have a chance to review those, we can have a short break to do that. Mr. Burchard, what is your comment on these?
Just 94 to 96, 99, and 101 were the consumer confidence reports. Marina will stipulate to the authenticity of the reports, but I don't think it's been shown. I don't understand what they're being admitted for. So I don't know how they're relevant yet.
Right, Mr. Scherzinger was not asked about these, and he would be the only witness with knowledge of them.
All right, what's Cal-Am's response to that?
So they're now authenticated and they're admissible as an admission as of a party. And they recite what the maximum TDS and chloride levels are and which wells they get their water from and which aquifers those wells access and the other topics that we've been discussing over these many days. But as an adverse party, they're admissible as an admission.
Yeah, I agree with Mr. Osias. They're authenticated, they're relevant, and they're subject to admissibility under the admission of party opponent exception to the hearsay rule. So I'm not hearing, and so I don't know that it matters whether or not Mr. Scherzinger specifically testified to them. I think they're admissible under those circumstances.
Mr. What are they being? What admission are we making? I guess is our biggest question.
Exactly.
I don't understand that at all.
Exactly. Without any questions to Mr. Scherzinger, it's a little unclear specifically the purpose. I mean, and we're not contesting that these are authentic, of course not.
Well,
we're just looking for a little bit of guidance on the purpose here.
Okay, well, my view is they're relevant because they do talk about the TDS. I mean, I can't remember all the details, but I believe they do talk about the TDS levels of the water that Cal-Am supplies to its that MCWD supplies to its customers. So maybe I'm not quite following. First of all, the admission exception, maybe it's not the right words, but that basically means these come in even though they're hearsay. They're not subject to the hearsay rule just because they're party opponent. That's end of discussion. as far as hearsay. So beyond that, I think your question is whether or not they're relevant. Is there something that you're arguing about they're not relevant?
I think the train of thought, and maybe there are just a couple of concepts that we're looking for connection here, may be that to the extent these are an admission that Marina Coast is serving certain quality of water to its customers, maybe there's some argument to be made about whether or not that's consistent with some position that Marina Coast has taken. And if CalAm would like to ask some questions about that, or Mr. Lilly, if you would like to ask some questions about that, that's why Mr. Scherzinger has stayed around.
The admissions exception simply is that these are documents that MCWD prepared. That's it as far as the hearsay rule goes, and there's no question that MCWD prepared these. So I maybe I'm missing something here, but I don't think so. I mean,
I think, Mr. Lilly,
we're talking relevance and we're talking hearsay. So tell me which one you are objecting.
So I'm going to handle this for.
Wait.
Lilly.
And only one of you gets
Yeah.
to talk at one time. So which one is it?
Kai, I'm going to handle this for Marina.
Go ahead.
Yeah.
Okay, go ahead, Mr. Bouchard.
There's no, as you noted, there's no hearsay objection.
Okay.
These are authenticated. I agree. The only issue is, from our perspective, would be relevance, because we don't understand exactly what admission they're being offered for. That's
You mean
the
what?
issue.
You not admission. You mean what purpose they're being offered for?
For what purpose? They're saying it's a party admission. What exactly
Correct.
is the admission?
What? No, not what's the admission. What is the relevance? Isn't that what you mean?
Right. The relevance to the 8 questions that the court has referred to the board.
Okay. So is that the objection?
It's a relevance objection, Your Honor, Mr. Lilly. Again, it gets over the hearsay by being a party admission, but what exactly is the admission? That's the point. What part of this, exactly what part of this pamphlet are we going to be looking at? What's the relevant
For
part of
the
the pamphlet that's
impact
coming
of,
in?
I'm sorry.
Wait.
I'm sorry.
You're both with the same party. You can't talk over each other. Are you done, Mr. Bouchard?
Yes.
All right, Ms. Muzine, go ahead.
How do these documents show us the potential impacts of CalAm's project?
Okay.
That's the relevance question.
Okay. So what's the response from CalAm to that? And again, I hope I'm trying to talk relevance here, nothing else. So does somebody from CalAm want to respond as to what's the relevance of these consumer confidence reports?
Yeah, yes.
Go ahead, Mr. Osias.
First, we've had Dr. Ash and others talk about public drinking water standards. He even referred to CCRs. Those are identified in these documents. We had questions about the quality of water going into the wells. Those are included in these documents. Meaning TDS and chloride. How that compares to the public drinking water standards. How that has changed or not over the last 5 years, pre-project, obviously. And the requirements for drinking water are referenced in these documents, all of which has been made relevant by the opening statements, written briefing, and testimony of Dr. Ash and Mr. Scherzinger and Mr. Long.
Okay. So my ruling on the consumer confidence reports, and that's exhibit CalAm 94, 95, 96, 99, and 101, is that they are admitted. The relevance objection is overruled. I think there are at least parts of these documents that are relevant to the hearing issues insofar as they talk about MCWD's position on the TDS of the water it supplies to its customers. So I'm going to admit them or accept them into evidence. I'm going to accept them into evidence, period. So that leaves
100?
let me go back. That leaves MCWD 90 through 93. Again, which are all, 90 is a section of the code of California Code of Regulations. Is anybody really going to object to 90? I mean, you could cite that in your briefs, even if it wasn't an exhibit. So does anybody object to CalAm 90?
I think you mean CalAm 90 to 93.
If I said something different, I apologize. I do mean CalAm 90. Thank you, Mr. Bouchard. I'd say I'm tired, but it's not even that late. Anyway, so does anybody object to CalAm 90, this being simply a section of the California Code of Regulations?
Mr. Lilly, if I could be heard on that, we've got exhibit 90 and then 106 through 113 that are copies of statutes. And in my experience, it would be highly unusual to admit a statute or a case as evidence in a proceeding. And so typically those are just cited. So I guess my question is why we're admitting them into evidence instead of citing them in briefing.
All right, what's CalAm's response to that? We normally do just cite regulations and statutes without offering them into evidence.
Thank you, Mr. Lilly. So the briefing will come at the end, but the witnesses are coming now, and to confront a witness with one of these, it needs to be in the record.
Okay.
And
So
not subject to authenticity objections, or where did it come from, or is that a complete quote? So
okay, yeah, I do think for that purpose, it's useful to have the documents in front of us, but please don't all start getting carried away and offer as exhibits every single regulation or statute you're going to cite in your briefs. But for that purpose, I think 90 comes in. 91 is not a regulation. Well, I'll just ask, does MCWD or City Marina have any objection to CalAm 91?
Well, Mr. Lilly, as with 90, I'm not sure that 90 or 91 have actually been presented to any witness in connection with a question. I may be mistaken, but that was my recollection.
Okay, so Mr. Osias, what's your response to that?
Twofold. One, when confronted with a site that said EPA 19, I'm doing it from memory, but EPA 1988, witnesses said, yep, we read those. And second, with respect to, so that was 91. What was the other section?
No, I think I've ruled that I'm going to admit exhibit CalAm 90. So exhibit CalAm 91. Is there anything else to say about that?
Again, it's for the detail that we can use in reference to their written testimony, which is already in, which cites each witness, including the ones coming up, but historic too, the table of sources of drinking water, potential sources of drinking water, potential beneficial uses, and they cite to EPA standards. This is part of those standards. So I think they've been admitted as for relevance. I don't think we have to ask questions. When I ask the witness a question and they don't know what they've read, it's pretty hard to go further in light of the way the hearings are proceeding and saying, well, how about this specific section? So.
Okay, I do have a little problem with 91. It doesn't have any date on it. So I'm not sure. It's going to be a little hard to use that for cross-examination, Mr. Osias, when we don't know when it went into effect or if it's still in effect.
I will replace it with a dated one. I apologize. It was printed off of Westlaw, I believe.
Okay. All right. So let's try to get through this pretty quickly. Wrap this up. I'm going to admit exhibit CalAm 90. I'm not going to admit exhibit CalAm 91, but I will leave CalAm the opportunity to submit a version called, which I ask them to label as CalAm 91 revised, which would have the date on it. And then we will decide in December whether or not to admit that into evidence. I'm not sure whether that's going to be used for cross-examination of a witness coming up in December. I don't think it's been used for cross-examination of any witness so far. Is that correct?
The answer is yes, it will be used in December, and we were going to use it, but the witnesses didn't admit any knowledge of the EPA 88 beyond a general one. So,
Okay, so that's it. So Mr. Osias, if you want to use Cal M91 in December, get a revised copy that has the date so we know what it is. Okay, Exhibit Cal M92 is a state water board order. Again, I don't require parties to submit those as exhibits, but I'm not going to, if somebody wants to use it for cross-examination purposes, that's okay. It certainly is something that we can consider in our processing. We certainly can consider state water board orders. So Exhibit 92 is admitted into evidence. Exhibit Cal Am 93 is the 2013 staff report. We previously posted that in the administrative record under a folder called either background documents or historical documents. So I'm not quite sure what the purpose is of admitting that into evidence. So I'll start with Cal Am. For what purpose is Exhibit Cal Am 93 being offered?
for use in cross-examination and impeachment.
Okay, I'm going to withhold ruling on that. I'll just say I have a problem admitting a state water board staff report into evidence because that technically could give it some evidentiary value. I think I can certainly discuss it and will discuss it in our draft report along the lines of here's what state water board staff concluded in 2003. I think that's very important background. Obviously, number one, it's not binding on the board because the board never adopted it. And number two, a lot has happened since 2013 in terms of additional studies in particular and other things. So I'm not sure how relevant that is or what evidentiary value it is. So let's leave. And again, that you may think about that, Mr. Osias, when you're preparing your cross-examination questions. It's important because the state board staff obviously spent a lot of time preparing that memorandum, but it is subject to the two limitations. It was not ever adopted by the board. Nobody ever asked the water board to adopt it. And it's now 9 years old, and there's been a lot of technical review since then. So 93, we're going to hold whether we accept that into evidence or not. 97 is an order from the California Supreme Court. Unless somebody has an objection, I don't understand. That seems like something we can take official notice of. It's certainly an act of a government agency. Does anyone have any objections to Cal Am 97? Hearing none. 97, Cal Am 97 is admitted into evidence. Cal Am 98 is the mitigation, monitoring, compliance, and reporting plan that I believe, well, I'm not sure. I believe that may have been adopted either by reference as part of the CPUC order approving the certificate of convenience and necessity. Is that correct?
Yes, and I also believe I think it's been offered by the city.
I think that is right, but somebody on cross-examination, is that correct?
Yeah.
I believe that there was I'm not sure if it's exactly the same document. It may be a subset, but I do think we offered some portion of it.
Okay, does anybody have so first of all, Cal Am 97 is admitted into evidence. Does anybody have any objections to Cal Am 98 being admitted into evidence?
Mr. Lilly, just if we can possibly clarify whether the document the city referenced in cross-examination is in fact this document, because it is dated 2019 MMP, and the PUC decision approving the project was issued in September of 2018. So it may have been that the decision contemplated this plan, but I'm not at all certain that this is a plan that the PUC has approved, but perhaps Cal Am can provide some further foundation.
Mr. Osias, can you provide any clarification on that? This seems like a pretty important point.
Not from firsthand knowledge. I apologize,
Okay.
Mr. Lilly.
So
I
let's
believe
leave.
it was printed out of the final EIR, but I will verify that for the parties.
Okay, so I mean, this one, I think I'll just say, I think it's pretty important that this be admitted into evidence, because I certainly do think it's relevant as to what, if the PUC has in fact ordered Cal-Am to take certain actions regarding monitoring, compliance, and reporting, I think that could be relevant to our process. But clearly we want to make sure we address the authenticity, what I'm going to call the authenticity issues that Ms. Muzine has just raised. So Mr. Osias, we'll put that one on hold, but subject to the comments I just made. So we'll leave it for you to circle back on that in December. Okay, I think we're almost there. Cal-Am 100 is an MCWD water master plan. Does anybody have any objections to that?
Mr. Lilly, so long as that's subject to the same representation by Cal-Am, that it's an exact copy of what they downloaded from Marina Coast's website, it's no objection.
Okay, can somebody from Cal-Am represent that? I'm going to trust an attorney if they say that they did in fact download it from Marina Coast website and did not change it. Can somebody from Cal-Am say that?
Yes.
Or confirm that? All right, Mr. Osias. So thank you, Ms. Muzine. So exhibit Cal-Am 100 is admitted into evidence. We already ruled on 101. So I think 102, we are now to, this is the 2020 MCWD Urban Water Management Plan. And again, Mr. Osias, can you represent to us that somebody from Cal-Am in fact downloaded this and turned it into an exhibit without making any changes?
Yes.
Okay, except obviously adding. the
Mr.
exhibit
Lilly,
number.
just for the record, the document does include appendices which are not included in the PDF of Exhibit 102. And we're not going to object to its submission over that. We just want to be clear for the record that the appendices are not included.
Okay, and if you think that the appendices end up being relevant, then you can offer those at a later date. Technically, if you offer them, it's not subject to the admission exception to the hearsay rule, but since it's a supplement of a document that Cal-Am has offered, I will accept those appendices into evidence if you want to offer them. But
Very
I'm
well.
not probably going to go find them on, well, I might. My staff might go look on the website, but otherwise, if you want them in, you're going to have to offer them.
And Mr. Lilly, just so there's no confusion by my response, the exhibit 100, my recollection is it had 3 appendices in addition to the very lengthy plan. I do not recall whether we included them in the PDF or not. We included for sure the entire plan. So
Okay. Same treatment for Ms. Muzine's as well.
Yes,
Fair enough.
we understand, Mr. Lilly, that the appendices were included with Exhibit 1, Cal-Am 100.
Okay, so then we don't have that issue for 100 apparently. Okay, so I think that gets us through the Cal-Am exhibits. And just to recap, they've been admitted, but subject to some qualifications, with the exception of Cal-Am 91, 93, and 98, which I'm not going to admit at this time, but those are potentially subject to Cal-Am offering those at a later date. So Cal-Am attorneys, please note that if you want to offer those at a later date, you'll have to remind me that you want to do that.
And
so is that clear?
Yes, and each of those should use the same naming style that you mentioned for 91, which is something revised.
Oh, if you need to.
Well, one of them needed a date.
That was 91.
Yes.
And I already said that. Cal-Am 91 would be Cal-Am 91 revised. Okay, I don't think you're going to need to change 93 or 98.
Okay, thank you.
Okay. I think
I'm sorry.
we have done, but I guess not. So first of all, Ms. Muzine, I think your hand was up first. Do you want to say something?
No, I didn't have my hand up again. Thank you.
Okay, Mr. Betts, your hand is up. Go ahead.
I apologize. I didn't hear if you thought we were done, and I'm not sure Mr. Size is done, but I do know we have 115, 116, 117.
Oh, okay. Those were not in Mr. Terry's email, so I didn't have those. What are 115 through 117?
115 is the letter that I referenced this morning with Mr. Long. where the city had approved of the expedited processing of the RDP Coastal Commission permit. I won't restate what it was, but it was the letter.
It was the letter signed by the prior city manager. Is that
Yep.
correct?
Yes.
Is there any objection to CalAm 115 coming into evidence?
Yes, Mr. Lilly, there's a lack of foundation objection. This is a letter that Mr. Long testified he had not seen before and did not know the context. And it does refer to a number of resolutions and various other things that are not in evidence. And so at this point, we'd object that there's no foundation for this letter.
So
Okay, that objection is overruled. I think Mr. Long said enough for me to be comfortable that a prior city manager actually did sign this letter. So I think it is authenticated. If somebody shows that some of these documents have been fabricated, we're going to have to go back to square one. I don't think any of you would do that. So I am going to go off the assumption that a prior city manager in fact signed that letter, and therefore it is authentic. It certainly is subject to the admissions exception to the hearsay rule, and it potentially could be relevant. I don't know how relevant, but it potentially could be relevant. So I don't see any valid objections to Exhibit CalAm 115. So I'm going to admit that into evidence. So what is CalAm 116, Mr. Betts?
116 was the phase one statement of decision concerning the prior RDP signed by Judge Carnow, and I can promise you I didn't fabricate Judge Carnow's signature. And 117 is the ensuing judgment. And those go to a theme that we've begun with, is that this project was previously approved of, supported by the city of Marina, MCWD, and it was only after they were hit with this judgment and award and weren't a part of this project that they came up with the new theories that they oppose the project for the recently minted theories that they do. But it's a very significant.
Okay, yeah, you don't need to get into all those arguments. Are there any objections to CalAm 116 or 117?
No, those are clearly officially noticeable documents.
Yeah,
Exactly.
those are officially noticeable documents. And whether or not they're going to be super relevant, I don't know, but I've admitted a lot of documents that may or may not be relevant to the, I will say, relatively narrow issues that the court referred to the State Water Board. We will admit those into evidence. Okay, does that take care of all the exhibits? I think it does. Okay, so I have just a couple of follow-up questions. First of all, Mr. Schwartzinger, are you there? I think I see you there.
Yes, sir.
Yeah.
Okay, there you are. And just a reminder, you are still under oath. I just would like you to clarify the history and current status of MCWD Well 12. We've heard, I'll say, conflicting statements regarding it. So what is the status of whether it's in service now, and if so, when it went into service?
So well 12 is currently in standby. So given, as I mentioned in the field, given its high thermal temperature, the water, when it comes out of the well, it's less desirable and for the community in that area. So well 12 only comes online when engaged or when necessary. So it's in standby as of this time. Mr. Long did not misrepresent the master water supply plan, water supply master plan. In that plan, we do identify the 7 active wells because they are our planning wells at this time. But we do have a capital program to bring well 12 back into full service.
And when is the estimated time when it would be back into full service?
It's currently on this year's capital plan, so I anticipate having it in service by June of this year.
June of, I assume you mean 2023?
Of this fiscal year, June of 23.
Okay, so you say it's on standby. Does that mean it's ever used now?
Not unless called on. So if we had a...
Well, wait. That's my question. Is it ever called on?
Currently, no.
Okay. All right, thank you. I think that clarifies that. We did hear something which I heard about for the first time yesterday, about a MCWD, a potential MCWD desal project. Can you tell us what that is briefly, or what the proposal is?
Briefly, yes, sir. So in 1996, the district constructed and operated and began to operate a 300 acre foot per year pilot desal plant. They ran that plant until 2003 and then put it in standby or mothball. In 2007 and 2010, the district considered restarting those facilities, but for whatever, and I don't know why the business decision wasn't made then to restart the facility. But currently, the engineering team at Marina Coast Water District is reviewing the project to develop a business plan, or to create the business decision to bring before the board to potentially restart the facility.
By the board, meaning the board of directors?
That's correct, sir.
And it's just the project being reviewed 300 acre feet per year?
Yes, sir. So the facility is there, Mr. Lilly. It's just in not great condition. So there's going to be a significant refit of the facility in terms of certain electrical components and other, some of the tankage needs to be replaced.
And it's 300 acre feet per year, the intake amount or the production amount?
That's the production amount.
Do you know what the intake amount would be?
No, not off the top of my head. I know that the intake well was rated at 300 gallons a minute.
Okay, so then just if you can tell me, that was my next question, was whether it's a well or a direct diversion. So what, can you tell me the depth and what aquifer it's screened in?
It's not actually screened in an aquifer, sir. It's actually in the beach sand. So the intake well is just south of the facility in the beach. It was drilled to roughly 95 feet from 34 feet above mean sea level. It is screened at 60 feet. There's a 20-foot screen. So it's actually, the intake is actually in the beach sand.
Okay, and how far from like the high tide mark is it?
So it was, okay, so at construction, it was 250 feet, but apparently storms in the 1990s reduced that. So it's actually in the dune, I guess you call it the dune cone. So it's right off the bluff in the beach sands.
Okay, and has there been any study by MCWD as to whether this would affect any of the groundwater aquifers?
So I would have to go back, but there was extensive environmental studies. There were environmental studies done during the operation of the facility from 96 to 2003, where both intake and injection, because we also injected back into the beach sands to confirm that the salinities along the beach sand in the tidal zone was not affected by the project.
And by injection, I assume you mean the brine product from the desal?
Correct.
Okay. All right. Well, thank you for that clarification. Let me just check my notes here. Do you, oh, okay. I'll start with this, and Mr. Crooks may be better equipped to answer this than you. Do you know where the regional desal project wells would have been located?
I do not, sir.
Okay, Mr. Crooks, I'll ask you to see if you know. And also, Mr. Schwartzinger, do you have any information regarding the historical water use on the Cemex property?
I do not.
Okay, then I'll ask Mr. Crooks that. Okay, so those were the questions that came up yesterday that I wanted to ask Mr. Schwartzinger. In fairness to the parties, you don't have to ask any questions. And if you do want to ask questions, I want you to limit them to what I just asked Mr. Schwartzinger. But we'll start with Marina Coast. Do you have any questions you would like to ask Mr. Schwartzinger? Any attorneys from Marina Coast?
No, Mr. Lilly.
Okay, and does the city of Marina have any questions for Mr. Schwartzinger?
No, Mr. Lilly.
Okay, and does Cal-Am have any questions for Mr. Schwartzinger?
No, Mr. Lilly, we do not.
All right, thank you. And does Cemex have any questions for Mr. Schwartzinger?
No, Mr. Lilly.
Okay, Mr. Schwartzinger, you got off easy that time around. And thank you for your information. That is helpful. Okay, so I'm going to just shift Crooks, is Mr. Crooks back? We are well after 2 o'clock. I guess I should have known that wouldn't be a problem. Mr. Crooks is over there. Okay. Oh, and just a reminder, Mr. Schwartzinger, you are still under oath. I assume that reminder does not change any of your responses, does it?
It does not, sir. Yes, thank you.
All right, thank you. So, Mr. Crooks, you still are under oath as well. And good afternoon. And as I say, thank you again for your tour guiding yesterday. I appreciate both Mr. Schwartzinger and you with very useful information. So a couple of questions for you. First of all, something I was really curious about, I wanted to ask you yesterday, but I figured it was better to get it on the record. When Cal-Am was running the test pumping of the test slant well, what did it do with the water that was pumped?
Yeah, that's a great question. I should have covered that yesterday.
Well, it's better to hear. We can all hear it better now. It was kind of windy out there.
So as you saw there on the site, there was piping above ground. That piping goes above ground and then goes below the sand and out to the beach. And out at the beach, the Monterey 1 water has their outfall has a junction box on the beach. And so that discharge piping from the well just is routed to the beach and into the junction box and goes directly to the back to the ocean through the outfall.
And is Monterey 1 water a wastewater treatment plant?
It is, yes.
Okay, so this was basically commingled with the treated wastewater effluent?
That's right.
Okay, well, that's good to know. Thank you. So then the next question for you is, do you know where the regional desal project wells would have been located?
They were vertical wells. My recollection from the EIR, which is available, I believe still out on a website somewhere on the PUC or whatnot, but there's an exhibit in the EIR, I think in section 5, where the project descriptions were, that has an exhibit that shows it. They were, my recollection, it was this generalized location, and it was and also recall that under the regional desal project, the wells were going to be owned by Monterey County Water Resource Agency. And the wells, I believe, were identified on the backside of the Cemex property, right at the bottom of the dunes along an agricultural area. And it was generally described as north of Reservation Road and south of Salinas River. And the exhibit had black lines on it to indicate where the wells may go.
Okay, when you say on the back side of the Cemex property, does that mean on the Cemex property or inland from the Cemex property?
I don't know. Well, I don't know because my recollection of reading it, it just stated that in itself. It didn't say whether they'd be on the Cemex property line, just adjacent to it, or a specific property. It kind of just it was a generalized exhibit.
Okay.
Now I also don't know, just to add to that, I don't know, as that project was being contemplated, if there was other more engineering type documents that had more refinement or specifics about where they would be identified. I've never seen those kind of level of documents.
That would be beyond the EIR.
Right.
Okay, and was that a final EIR?
It was.
Okay. Okay, I don't know if it's relevant or not, but if we want to, we may go look for it. Okay, and then my last question for you, last line of questions for you, Mr. Crooks. Do you have any information regarding the historical water use on the Cemex property?
I don't.
Okay, so this is something I'm not quite sure how to address this, and I'm not even quite sure how to ask you to address this, but I really would like to know the historical use. I think I mentioned before, I'd like to know the acre feet per year of historical use, where the water came from, particularly whether it was pumped on the Cemex property or brought in, import, whatever you want to call it, from somewhere else, what the purposes of use were, what the TDS was, and so forth. Because I do think this could be relevant to this question of 500 acre feet per year of historical use. And nobody's offered any evidence on this. So does anybody want to say anything about this issue today, like whether or not they want to offer any evidence on this, or whether or not they think evidence on this would be relevant? I don't know, is it?
So, Mr.
I'll
Lilly,
for hands. Go ahead, Mr. Newdecker, you're a client, go ahead.
yeah, so you mentioned this earlier, so I jotted down a note to look into this, and I will, and I can report back. But, I also, I want to manage expectations too, because, to state the obvious, this isn't Cemex's project, nor is Cemex opposed to the project. So unlike every other party in this proceeding, we haven't spent a decade briefing these, issues to the PUC and the State Water Resources Control Board and everybody else. The 1996 annexation agreement, let's also keep in mind, that's a 26-year-old document that was entered into not by Cemex, right? It was entered into by a completely different company that Cemex acquired, I believe, 18 years after that agreement was signed. Because of the 2017 sand mining settlement agreements, Cemex hasn't been able to do mining for the past 5 years, which is what the property was used for a century before then, and it's under orders to sell the property. So all of that is to say, I'll look into this, but information that other parties to this referral have at their fingertips, I don't know that Cemex does. So, and the background I gave is to kind of explain why that may be the case. So I'm happy to look into this and talk with my client and see what they have, but I do want to manage expectations for what can be presented in this referral proceeding.
Okay, well, that's a candid and helpful response, so I appreciate that. Does anybody else want to say anything about this today? I don't know whether I don't know what. As I say, you can see why I'm interested, but I can understand your challenges. Go ahead, Mr. Wilkins.
I will say that the Marina Coast Water District is interested in this information. We did ask, I think, one of the CalAm witnesses who said that they believed they had some information on it in one of their reports. To my knowledge, we have not seen that information, and it's something we have been looking for some period of time. I know there was a meet and confer process about this with Mr. Brochard and Mr. Newdecker. But at the end of the day, we would like information about the water use on the property, and we do reference it in our testimony from our experts. So I do think it's relevant. I don't know if I was not involved in the meeting conferred, so I don't want to make any representations. If Mr. Newdecker or Mr. Brochard want to talk about that, just so you can understand maybe more context here, that might be helpful at this time. It may not be. So I just want to let you know that we do believe it's relevant.
Mr. Brochard, do you want to add anything?
Mr. Newdecker told me what he just told everybody else a few months ago. So no, nothing's new. We have some discovery responses that we could submit to the AHO from Cemex that does nothing more than state that they don't have any information stating that they pumped more than 500 acre feet per year from the property since the 96 agreement was entered into. And that comes with a caveat that they also can't locate records prior to 2017.
Okay, I would appreciate that if you would submit those to the AHO.
Sure.
I think we may be starting to compile some AHO. Well, I don't know. Do you have any objection to just labeling that as another MCWD exhibit?
I don't. I will submit them as MCWD exhibits.
Okay, why don't you do that as the next? I'm going to go through all my notes and prepare a list of everything I've asked all of you to do. It's not that much, but it's probably good if we're all on the same page. But I think that would be useful, Mr. Brochard. And basically, if nobody comes up with any more detailed evidence, I probably will cite that in the report and basically say, this is the most information we have about this topic, at least that we've obtained so far. So beyond that, I'm going to think about whether or not to order anybody. I mean, I can't order you to produce something you can't find, but I can order you to look. So let me think about the best way to proceed on this. I'm being fairly candid about what what my quandary is here, but I understand you can't produce something you don't have. So we'll deal with that. So, okay, go ahead. Somebody wants to say something.
This is Mr. Osias. So to the extent and I have no knowledge beyond anything you've heard today, so this is just a procedural question. If we find information relevant to your questions, would you like us to submit it with a short direct testimony about it? Or just, I mean, we may, we'll see what we can find, but then how do you want to communicate it, I guess, is the best question.
Yeah, it would be best. I mean, presumably if you find something, somebody had to do some work to find it. So that person presumably could testify briefly, here's what I did to find this information and here's what I found. So I think it would be, I mean, you know how we do written proposed testimony in this process. So I think it would be good to do that, just so, then that person, obviously I'll ask that person to take the oath, and that way we have it in the record as evidence. I mean, I suspect the person's going to say something to the effect of, I went to these files and here's what I found. They're not going to have personal knowledge, but whatever. So yes, if you can do that, I'll try to put a deadline in for that request as well. And that's for any party that wants to do that. So I have no idea which way this cuts. It may depend on what the numbers are, but so I don't know who's interested might be or not interested might be, but I just think it's going to be relevant. I mean, I've worked with my board members now I've been in this job just over 3 years, and I've worked with them a lot, and I can just see them asking me this question. So, and of course I report to them. So to the extent we can anticipate that and be able to answer that, I think that would be useful. So, okay. As I say, we will put together a short hearing officer's order listing the things that we want people to submit. I don't think there are very many things left, but there are a few. And I'll get that out as soon as I can. I do have a couple of other proceedings I have to get caught up on, but I'll try to get that within a week if I can. I would like each of you, without a written order, but I'm just asking you, by the end of the day tomorrow, please submit an updated Excel file. And probably easiest thing is to just upload it to your exhibit list, and you know the drill, and send us the AHO an email with CCs to the parties on the service list stating that you've done that lists all of your party's exhibits to date. And then we will work hard to prepare a list that will have the status of all those exhibits so that everyone's on the same page on that. I think that's really important to get done before we go to the next round of hearings. So we will do that. And then we are scheduled, I believe it's December 7th is when we are scheduled to come back. So is there anything else we need to cover today? Mr. Osias, your hand is up again. Go ahead.
And I apologize.
You don't need to apologize. Just go ahead.
Well, so I just wanted to let you know that on December 7th, for a health-related reason, I may not appear until 9:30. I have an early morning doctor's related appointment, which I could not change. And so if I'm not there right at the beginning, I will show up as soon as I can. I didn't want to appear rude.
Okay, well, I certainly hope things go well. I do know how hard it is to get doctor's appointments. I think we'll go ahead and start at 9. I mean, Cal-Am certainly has you're one of their very qualified attorneys, but they have other very qualified attorneys. So I think we can go forward for that half hour. We'll probably be primarily in opening statements anyway. and then in summaries of testimony. So is that okay with you if we go ahead and get started at 9?
Yes, I had no request. I was merely trying to explain my absence temporarily.
Okay.
Which you may not remember at that time, but I'll feel better.
Yeah, well, no, I appreciate your letting us know. I certainly hope things go well from that. Okay, let me just, oh, yes. Mr. Woldridge just sent me a text on the side, which I want to pass on to you. He and Ms. Graziano will be compiling the photographs and videos that they took yesterday during the site visit into an organized, I'll say, set of files within some folders with a photo log and a video log that describes what they took, so that we can put that into the record. I don't know, it takes a while to do that. I mean, Mr. Woldridge, he's done this in other proceedings. He's quite good at defining the locations of each picture with coordinates and things like that, and potentially even a map showing where the photographs were taken. So it's a useful document, but it takes him a little time to do that. But we will get those up to the AHO FTP folder as soon as we can, and of course we'll let you know when we do that. So thank you, Mr. Woldridge, for advising me of that. You all were those of you who were there know it well, but for those who were not there, and particularly for the board members and potentially the judge, I think it is useful to have the site visit videos and pictures just so that they can get a little bit better of a feeling of what's actually out there in the field. So we will do that. Okay, so I hope nothing else comes up between, I guess I should ask, the third rebuttal testimony by the 3 expert witnesses, Nelson, Kincaid, and Trudell, I believe is due, the written proposed testimony is due November 14 with any associated exhibits, and I have ruled on what the scope is for that. I think we did schedule dates for those depositions of those witnesses. Is that correct?
There's a range of time in which we can schedule those depositions, correct?
Okay, so I'll just say, please try to be professional and somewhat cooperative. I think I know Thanksgiving is right in the middle there, but if you can try to get them done sooner than 7:30 in the morning before the day the hearing starts, I think it would really be good for all of us so that we can get the transcripts up as necessary. It's just 3 witnesses, so it shouldn't take a long time for those depositions, but please try to all work together to schedule those to do as soon as you can after November 14th when they file their written proposed rebuttal testimony. Okay, so I think I've covered all the topics I have. I'm not seeing any more hands up. So of course, if something comes up, let me know and we'll schedule a status conference, but I hope we don't need to. And with that, I will see you all on December 7th at 9 a.m. So thank you all very much. Have a happy Thanksgiving between now and then, and I'll see you all then. Bye.
Thank you.
Thank you.
Thank you.